All right, 10 o'clock. Why don't we call this public meeting of the State Ethics Commission to order. Let me first start with an opening statement before, or actually, I guess let me first start by taking attendance. Commissioner Reddycliffe. Here. Commissioner Parcells.
Here.
Commissioner Caruso.
Here.
And unfortunately, we know that Commissioner McKee Vasello is absent today due to a last-minute illness. And I am here, so there's only 4 of us here today, but we do have a quorum. Pursuant to the Public Official and Employees Ethics Act, Act 170 of 1978, as amended by Act 9 of 1989, June 26, 1989, and as amended by Act 93 of 1998, the State Ethics Commission is specifically mandated to hold at least 2 public hearings each year, of which at least 1 shall be held in Harrisburg and at least 1 shall be held in a location other than Harrisburg, to specifically seek input from persons and organizations who represent any individuals subject to the provisions of this act and from other interested parties. We have placed on the agenda for today's public meeting a notice that the Commission will be meeting today in part to receive input or testimony of individuals pursuant to the provisions of this law. As our previously published notice has indicated, the Commission will request copies of any statement that is presented. The individuals presenting statements before the Commission shall be allocated 15 minutes to complete their statements. Statements shall be uninterrupted, except that statements may be interrupted or terminated by the presiding officer if it is determined that the statement is impertinent, scandalous, or otherwise improper. Also, let me make an announcement that pursuant to the requirements of the Sunshine Act, the holding of an executive session must be announced at the public meeting immediately prior to said executive session or at the next meeting thereafter. An executive session will be held today, January 14, 2026, immediately following the session to review matters that are by statute confidential, including the review of completed investigations for the purpose of issuing final adjudications, the review and consideration of applications for 90-day extensions of investigation filed by the investigative division, and administrative matters. With those preliminaries, the first item on the agenda is the minutes of our September 18th, 2025 public meeting minutes and our December 5th, 2025 public teleconference meeting minutes. If there is no objection, I'll take those 2 meeting minutes together. Has everybody had a chance to review those minutes? And may I have a motion to approve those minutes?
So moved.
May I have a second?
Second.
Any comments, any clarifications on the minutes? Hearing none, all in favor of adopting those minutes, say aye.
Aye.
Any opposed? The minutes will be adopted. We are going to move to administrative penalty orders default. The first one is Scott's Miracle-Gro, and I will present that. Respondent Scott's Miracle-Gro is a registered principal that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the second quarter of 2025. A warning notice was issued to Scott's Miracle-Gro, but the respondent, Scott's Miracle-Gro, failed to comply within the 30-day cure period that's provided in that notice. Based upon the record before us, it is my view that the respondent's transgressions of the lobbying disclosure law were negligent in nature. In accordance with the Commonwealth Court's decision in Penn Film Group, the The record was examined for any mitigating factors, such as those outlined in section 63.63 of the Commission's regulations. There is no evidence of any other mitigation present in this case, other than it appearing to be the respondent's first time failing to file a quarterly expense report. In the absence of any other mitigating factors of record, I conclude that the maximum civil penalty in accordance with section 13A09C of the lobbying disclosure form is appropriate in this case. Therefore, I would make the following motion. Based on the totality of the circumstances in the case, including the lack of noteworthy mitigating factors, I move that this commission levy upon respondent Scott Miracle-Gro one maximum administrative penalty in the total amount of $31,100 for its failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the second quarter of 2025. Finally, I move that the respondent be ordered to pay the aforesaid administrative penalty by no later than the 30th day after the mailing date of the Commission's order.
Excuse me, Mr. Commissioner, I just want to raise an issue with this one.
Yes, please.
That, you may not be aware of, or you would not be aware of. Scott's Miracle-Gro on December 18th, 2025, filed both its second quarter 2025 expense report and its third quarter 2025 expense report.
So if I hear you correctly, it has now come into compliance for the second quarter and it has filed a third quarter.
Yes, as of December 18th,
Okay.
2025.
And may I ask, does the filings for the second quarter or the third quarter disclose any lobbying expenses, or is it a statement that they don't meet the reporting threshold?
There are lobbying expenses disclosed.
Is there any statement in the belatedly filed second quarter statement that would be any mitigating factors for why it was not filed on a timely basis?
I do not see anything reflecting that.
And have you heard from anyone on behalf of Scott's Miracle-Gro about the default for the second quarter?
We have not. They have not contacted the investigative division at all.
I will renew my motion. Is there a second?
I'll second it.
Any discussion or any need to go into quasi-judicial deliberations on this one? I appreciate you, Ms. Lehman, supplementing the record on this. My sense is it doesn't add any mitigating factors. The fact that there was expenses as opposed to no expenses is not a mitigating factor. They've come into compliance, and certainly the type of entity we're talking about, if there were mitigating factors, they would have the ability to raise that with us. So, any other thoughts, comments before we take a vote? Hearing none, all in favor of the motion, say aye.
Aye.
Aye. Any opposed? The motion carries. Now, there are two other administrative defaults that are assigned to Commissioner Parcells. Originally, we expected Commissioner McKee-Vassallo to participate in those matters, and I was going to be recused for the reason that my law firm, Troutman Pepper Locke, represents Scholastic Inc. and Rite Aid. I do not personally participate in either of those two representations. And Ms. Guilfoyle, given the lack of a quorum, if I recuse, I understand that you have advice to the commission regarding the rule of necessity.
I do. As you indicated, we did intend that Commissioner McKee-Vassallo would be here today, which would have been enough for a quorum without your participation. And it is my understanding that you have recused yourself from these cases due to the potential for a conflict based upon your firm's representation of both Scholastic Inc. and Rite Aid in other matters, not these particular cases. It's also my understanding that you have not done any work for either of those two entities, and that although you are an equity partner in your firm, that any compensation that may have flowed from work done on behalf of or for Scholastic Inc. or Rite Aid would be of a de minimis nature to your overall compensation package. So based upon that information, we have the rule of necessity, which is a common law principle that allows an individual who would otherwise be recused to participate in the event that otherwise the business cannot be transacted, which is what we have here. So based upon that, it is firmly rooted in common law and case law to support it. In fact, we have a version of this in our own ethics law itself. I would recommend that that the commission invokes the rule of necessity and that you participate in the voting and the deliberations involving Scholastic Inc. and Rite Aid in these cases.
So let me suggest a procedural mechanism. Let's first take a vote of the commission to see if the commission agrees that it would be appropriate for me to invoke the rule of necessity and participate in this.
I would move that we invoke, in this particular case, the rule of necessity.
Second.
Ms. Guilfoyle, am I allowed to vote on this procedural motion? Or do I need to vote as part of the rule of
That's a good
necessity?
That is a very good question. Which, again, I think if we do, I think we're risking a paralysis situation. If you can't vote on invoking the rule of necessity, then it can't be, it's a circular theory. So I would recommend that you do in fact vote on invoking the rule of necessity, and that then the commission can proceed from there.
And I will, based on that advice, participate in this decision. Is there any discussion on the motion that has been seconded? Hearing no discussion, let's take a vote. All in favor, say aye.
Aye.
Aye. All opposed? Hearing none, I will participate under the rule of necessity. And Commissioner Parcells, if you'd like to present these cases to us.
All right, we have two default administrative penalty cases. Respondents Scholastic Inc. and Rite Aid are registered principals that failed to timely file either a quarterly expense report or a statement of failure to meet the reporting threshold for the second quarter of 2025. Warning notices were issued to the respondents, but the respondents failed to comply with the 30-day cure period provided. Based on the records before us, it is my view that each of the respondents' transgressions of the lobbying disclosure law were negligent. In accordance with the Commonwealth Court's decision in Penn Film Group, the record was examined for any mitigating factors such as those outlined in section 63.63 of the Commission's regulations. Other than this appearing to be the first time either respondent failed to file a quarterly expense report, there is no evidence of any other noteworthy mitigation present in these cases. In the absence of any other mitigating factors of record, I conclude that maximum civil penalties in accordance with section 13A09C of the lobbying disclosure law is appropriate in each case. So I'd like to move that based on the totality of the circumstances in these cases, including the lack of any significant mitigating factors, I move that this commission levy upon respondents Scholastic Inc. and Rite Aid one maximum administrative penalty each in the total amount of $31,100 for their failure to timely file with the Pennsylvania Department of State either a quarterly expense report or a statement of failure to meet the reporting threshold for the second quarter of 2025. Finally, I move that the respondents be ordered to pay the aforesaid administrative penalties by no later than the 30th day after the mailing date of the commission's order. That is my motion, Mr. Chairman.
I second it.
Any discussion on the motion on the two cases, consolidated motion?
The Attorney General might have his work cut out for him collecting on.
I understand that, yes, we understand that, especially with regard to the Rite Aid matter. We've reviewed the bankruptcy records, the documents, and it appears there are significant assets, and I think we have an obligation to collect what we're able to collect.
Agreed.
Okay, all in favor of the motion, say aye.
Aye.
Any opposed? Motion carries. Just a quick question, if I may, going back to the Miracle Grow. Given the additional information, I just wanted to confirm, is the calculation of the penalty still correct with the filing of that?
The calculation of the penalty is based on the date that we filed the petition.
And the petition was filed prior to the time of the amended?
Yes.
Okay, I just wanted to confirm on the record that we didn't need to, on our own, sua sponte, fix any of the penalty provisions, but hearing what you said, there's no need to go back to that. But thank you for filling that in. We have a administrative penalty order consent this time, Envision Human Services. Commissioner Purcells.
Respondent Envision Human Services failed to timely file its quarterly expense report for the first quarter of 2025 in its capacity as a principal. The parties agree that respondent's transgression of the lobbying disclosure law was negligent. The respondent has now submitted its delinquent expense report to the Department of State. Based on my review of the facts, in particular the considerable mitigation offered by the respondent as set forth in the order, I am of the opinion that the consent agreement sets forth a proper disposition for this case, and I would like to make the following motion. I move that this commission approve the consent agreement submitted by the parties and oppose the following administrative penalty. As to Envision Human Services, one administrative penalty in the total amount of $4,800 for its delinquent expense report for the first quarter of 2025. I move that the respondent be directed to pay its administrative penalty to the commission by no later than 30 days after the issuance of the commission's order. That's my motion, Mr. Chairman.
Is there a second?
I'll second.
Okay. Any discussion? Only comment I have, and I think this is a general comment, and I think it's a compliment to the enforcement people, the investigative division. I do think it makes sense when principals or lobbyists fail to timely comply, even when there's a warning notice, that they reach out to the commission, because I think this matter, if approved, demonstrates that there is mitigation offered to reach a consent agreement and to allow the case to proceed in default. So with that comment, let's take a vote. All in favor, say aye.
Aye.
Aye. Any opposed? That motion carries. All right, we have an interesting, complicated reconsideration request. I guess reconsideration was granted, although we have not decided whether or not we're going to change our view. And Ms. Guilfoyle, you were appropriately asked to present this to us, given the complicated procedural nature of this. So the floor is yours.
Thank you. Yes, I did ask just because this is a procedurally detailed case, and I will set it up for you so that you can then have some discussions and deliberations on what you would like to do with this case. This began when the investigative division initiated enforcement proceedings against Button Holdings pursuant to the lobbying disclosure law. Although there was signature evidence of delivery of this action by the U.S. Post Office to Button Holdings failed to respond in any way to the allegations. Consequently, a default was entered, and on July 23rd of 2025, the Commission issued a default adjudication and order imposing the maximum civil penalty of $32,300 against Button Holdings for failing to file a fourth quarter 2024 expense report or a report that it did not meet the reporting threshold. So after that time, August 12th, 2025, Button Holdings filed a motion for reconsideration, asking the commission to reconsider its order on the basis that its failure to file was what they loosely described as an inadvertent clerical error, and because the investigative division's email notification went to a junk email folder and was not discovered until after they had received the commission's adjudication and order. The investigative division filed a response and attached a copy of the United States Postal Service green card with the signature of Ed Button on it. Button Holdings then responded that the signature was, although it was signed Ed Button, it was actually signed by someone other than Mr. Button. And through internal inadvertence, the certified mailing never made it to Ed Button's desk, and so that was the reason that they never responded. So based upon the pleadings that were filed in accordance with the reconsideration request, the commission on August 19th, 2025 issued an order granting the motion for reconsideration, primarily to retain jurisdiction so the jurisdiction would not be lost to Commonwealth Court, and to consider arguments of whether there had been any material error of law or fact, or whether any new evidence or facts previously undiscoverable had been provided that would lead to a reversal or a modification of the order that was previously issued. Oral argument was then scheduled to be held at the Commission's September 18th, 2025 meeting. However, the parties subsequently requested to submit the case on deposition testimony and briefs. The depositions of 2 witnesses were completed on September 12th, and the parties then submitted the transcripts as well as briefs in support of their respective positions on November 14th of 2025. So based upon a review of the procedural history of this case, and I did in fact, of course, review the deposition transcripts as well as the parties' briefs, there seems to be 2 issues that need to be deliberated by the commission. One is whether the respondent, Button Holdings, has shown an excusable neglect as to the warning notice, and 2, whether they have presented any mitigating factors to justify a lesser financial penalty than previously imposed. So based upon this factual history, I would recommend that the commission go into quasi-judicial deliberations to discuss and decide the issues presented to it, and then the commission can report out with a motion directing what final decision it would like to have in its order to be issued after this meeting.
Let me ask a question. Is any representative from Button Holdings, did they express a desire to participate in today's hearing?
I have not heard anything from anyone from Button Holdings.
Did they know that this was on the agenda for today?
That I do not, I also do not know that, to be honest. I think that we sent a notification, but I'm not 100% sure.
Anyone else know?
We can check
Yeah.
our email and see if,
I've been the attorney for the investigative division on this matter. I did not advise them.
In reading the materials, it appeared as if the parties agreed that this would be submitted on the deposition and on the briefs. Is that accurate?
That is accurate. So I wouldn't expect that they would be appearing today because there was not going to be an opportunity to make any, unless the commission asked for it. This was merely to be a deliberated matter by the commission.
And was that the understanding of the parties, Ms. Lehman, that this
Yes.
would just be deliberated by the commission?
Yes, and I will say in all candor, I had a very friendly relationship with opposing counsel. I very well could have said the commission will likely hear this in January, but I did not send anything formally or advise them.
Okay. And I do see someone on our Zoom who I think I recognize as a member of the Ethics Board in Pittsburgh. I assume no one from Button Holdings is on our video. So if that's the case, if I can ask us, can we mute our sounds so that the folks on the video are not able to hear our deliberations?
I can do that,
Let's just mute our sound. I don't think we have to log on or. Ms. Davis, are you able to hear us? Good. Just want to make sure we're publicly broadcasting. We have gone into quasi judicial deliberation on this matter, and I have a motion to make. My motion is that based on new evidence which was provided to us, which would lead to a modification of our prior default order, and which we believe could not be and was not discovered in the exercise of due diligence, that we would modify our prior order, still leave the default in place, but impose a penalty in light of the factors to be considered by Penn Film Group in the amount of $7,000. Do I have a second for that
Second.
motion? That motion's been seconded. Any discussion on that motion? Hearing none, all in favor, say aye.
Aye.
Any opposed? No, motion carries. And I'd ask that the legal division prepare an order implementing the affirmance of the default, but the modification of the penalty for the reasons we stated. Okay, we have a group of civil penalty defaults. Commissioner Caruso?
Thank you. There are 4 civil penalty default cases now before the commission for decision. Respondents involved in these cases will be identified individually in the motion I will be making with regard to these cases. These respondents failed to file statements of financial interest for the calendar years that I will detail in my motion. Respondents did not take action or otherwise respond to the civil penalty proceedings. Following review, my opinion that as to each respondent, the commission should levy a maximum civil penalty for each delinquent statement of financial interests. It is my opinion that the commission should also order these respondents to file their statements of financial interest. There is nothing of record that would constitute a defense or their noncompliance with the requirements of the Ethics Act. Based upon my analysis and comments, I would like to make the following motion. I move that this commission levy maximum civil penalties against the respondents in the following civil penalty default cases as follows. I move that this commission levy a maximum civil penalty in the total amount of $250 against the following respondents for failing to file a statement of financial interest for calendar year 2023. Nathan Smith, Robert Fox, Robert Allison, and George Lambert. Further, these respondents shall be ordered to file complete and accurate statements of financial interest for the years stated within 30 days of the issuance of the commission's orders. That's my motion.
You have a second?
Second.
Only comment I'd like to make, not that there's ever an excuse from what agency people are with, but I'd just like to comment that Nathan Smith is a narcotics agent with the Attorney General's office. It's a law enforcement agent. I think he has even a higher duty to make sure that
Absolutely.
these are appropriately completed, and would suggest that we may want to make sure that the agency is aware of the order that we intend to issue so that it can take whatever disciplinary action it may be appropriate.
Certainly will do.
I just had one question I wanted to ask Mary or the investigative division. I noticed all 4 of these are either Commonwealth employees or former employees or serve on a Commonwealth board. Are they any of these? Are these all formers or?
I do not believe they're all formers, and Julie Carabin from our office can respond. Sure.
According to our records, George Lambert and Robert Fox are both formerly with their positions, but Robert Allison and Nathan Smith are still current.
That's surprising.
Yeah, and that may be a broader question too, to think about of whether we should, in addition to our normal notifications and publications for current Commonwealth employees, make sure that their supervisors are aware of the order, because it is possible that the agency may wish to take disciplinary action if appropriate under those circumstances. So I think we had a motion, we had a second. Any other comments? Or questions? All in favor, say aye. Aye. Any opposed? No, the motion carries. We have a consent for a civil penalty order, Commissioner Caruso.
Thank you. There was one civil penalty case with a proposed consent agreement for the commission's consideration. This case involves respondent John Pavella, a member of the Uniform Construction Code of Appeals Board for Donegal Township, who failed to timely file a statement of financial interests for calendar years 2021, 2022, and 2023. Parties have submitted a consent agreement proposing that the commission find that the respondent failed to timely file a statement of financial interest for the years stated and impose the civil penalties that I will detail in my motion. I note that respondent has now filed his delinquent statements of financial interest for calendar years 2021, 2022, and 2023. Based upon my review of the facts, I am of the opinion that this consent agreement is a proper disposition for this case. It is my opinion that the commission should impose the civil penalty agreed to by the parties per the consent agreement. Based on my analysis and the comments, I'd like to make the following motion. I move that this commission approve the consent agreement submitted by the parties, imposing a total of $500 civil penalty against respondent John Pavella for failing to timely file statements of financial interest for calendar years 2021, 2022, and 2023. I further move that to the extent that the respondent has not already done so, respondent shall be ordered to pay the recommended civil penalty amount agreed to by the parties per the consent agreement within 30 days of the issuance of the commission's order.
We have a second.
Second.
Any discussion? Hearing none, all in favor, say aye. Aye. Any opposed? Motion carries. Before we get to administrative items, I think we realized from what the legal division did on the Scotts Miracle Grow case that we may have calculated the penalties through to today rather than the date on which the filing was made, which I believe, Ms. Lehman, was that December 18th?
Yes.
Have we had a chance to calculate what the penalty should be if it was to December 18th?
We have. I would recommend that you rescind your prior motion and make a new motion where the civil penalty would be $25,500 as calculated from the date of the filing of the notice of noncompliance until the date that they in fact filed their report, which was December 18th, 2025.
Very good. So, sua sponte, we'll reconsider the prior order we entered, and I'd move that we modify the penalty for Scotts Miracle Grow in light of their filing in December, so that the total penalty would be $25,500. We have a second to that motion?
Second.
Any discussion? Other than thank you for raising
Yeah.
and getting that appropriate cured in the same meeting. We'll take a vote. All in favor?
Aye.
Any opposed? No, that motion carries.
Thank you.
Administrative matters.
As I have an operational report to present to the commission. The first item is our budget for the fiscal year 2025, 2026. We are currently projected to have a surplus of $57,245 for the fiscal year. When we calculate these projections, we look at what we expect we're going to spend for the remainder of the year. There are some items that we have identified as potential purchases, and I think we're going to hold off until next year to purchase. So I do expect that amount in terms of surplus will go up slightly for a surplus for this fiscal year. Um, Also, as part of our executive meeting, I am going to request the approval of participation for some of our employees in the annual leave sellback program. If you do approve that, and if our employees that are eligible for that buyback participate, it would reduce the amount of to $52,237. But these are all projections, so certainly these are going to change as to make purchases and sign on to these certificates. In addition, as of November 30th, 2025, we have a balance of $37,800 of unused fiscal 2024. And our continuing appropriation fund is balanced $1,935.07. We've done quite a bit of external training this year, or in 2025. We conducted 22 in-person and virtual trainings, totaling 48 hours of education and reaching more than 2,326 professionals. Already have 17, I think we actually have more than 17 scheduled for 2026. So we'll continue substantive outreach program. I reported in my materials that we are working towards becoming a continuing legal education provider. I'm happy to report that we underestimated how many we had received credit for. We are actually currently eligible the application to become a CLE provider, and we completed that application yesterday. As soon as we're able, we're going to submit that to the CLE board to be an accredited CLE provider. The benefit for this is we'll be able to offer CLE credits to lawyers that trainings at a very reasonable fee, and they are the very valuable ethics credits that all lawyers need. So we're really excited to be able to offer this. We hope that that means more solicitors attend and we get additional compliance on our cases and compliance with the ethics. 2025, our legal division issued 65 advisory opinions. Our investigative division, 7 of which we opened to full investigations. We are currently on hold with referring matters to the Attorney General's office. They have requested we hold off on sending cases due to a cybersecurity that occurred in August. It's not fully resolved, it's partially resolved as of our recent communications with that division. We currently have 11 civil penalty cases that we're ready to refer as soon as they're ready to accept these cases.
And just to be clear, that's for civil collection. That doesn't impact the referral or the publication of our findings for which the Attorney General could conduct a criminal investigation.
Correct.
Right?
Correct. What these cases are situations where the commission has already issued an order, and that order involves someone having to pay a penalty, and they have not paid the penalty even after receiving additional notification from our office. So we give people the opportunity, we give them 30 days to make good whatever payment, whatever's owed. And we do provide them notice. We also make efforts to engage in payment plans whenever we can. We want compliance. We only refer these cases to the Attorney General's office as sort of a last resort.
Thank you.
I am very pleased to let you know that we have completed developing our new SFI filing system. We're currently in a pilot phase. We have about 80 people who have agreed to participate in the pilot and file their statements of financial interest through the system. We do this as a pilot because I didn't want to roll it out statewide without working out the bugs that we expected to have. I'm not sure of the number of people that have already used the system. I've personally filed my statement of financial interest already, and a number of staff members have. We've discovered a few small things that we want to change and tweak, but I'm really pleased to report that we've got good feedback. Hopefully this makes the filing much easier for everyone next year. Anyone's interested in participating, we can provide the vendor with your information and you'll receive an email and access to file your form. I'm looking for feedback. I'm looking for brutal feedback because if we're going to have mistakes and issues, I want to do it now because the plan is for this to be rolled out statewide in January of 2027. And I also want to give kudos to our team. worked very hard, and the members of the people who worked for with the vendor on this, they were wonderful to work with. They really put in a lot of hours to make this happen. So I'm thrilled. We are completely relocated into our new space and we're settling in. We've already noticed improvements and collaborations. Then I wanted to update you on our fiscal year 2026-27 appropriation request. It was due in late October 2025. We submitted our request to the Office of the Budget. Our request was 4.146 million, and it was broken down as follows. 0.628 thousand is for personnel expenses, and those personnel expenses are salary, benefit, and wages, which include per diems for the commissioners themselves. So as you can tell, almost all of our funds are spent people on the work that they're doing. And then $514,000 of that was for operations. Of that, $108,500 is money that we will require in order to do the full rollout of the new SFI system in January 2020. This is a 22% increase over our prior year's expenses. And the reason for that increase is primarily due to a cloud backup system contract due in July 2026. An increase for the cost for IT and HR services provided for the Office of Administration, and increased subscription costs for Thomson Reuters products that are used by our investigative team as part of their investigations. In addition, we have $4,000 fixed asset expenses for the maintenance contract for our Pittsburgh offices. Excluding the request for the additional funds for the SFI filing system, this represents an approximate 6.4%, $261,500 increase over the Commission's actual fiscal year 2025-26 actual appropriation. We asked for, we're hoping to receive it and allow us to continue the work that we're doing.
Any questions? So we're going to move to our regulations. We've spent a lot of time, a lot of effort, and when I say we, I think Bridget has done the yeoman's work on making sure that all of our comments, all of the public comments have been incorporated into a set of proposed regulations. I understand that the purpose of the agenda on today's meeting, after giving notice to all kinds of interested stakeholders, including members of the legislative caucuses and others, is to seek authorization from the commission to begin the rulemaking process, which, as we know from our technical amendments, goes to the Independent Regulatory Commission, then gets published for public comment, and comes back to us to respond to any comment before becoming finalized. Bridget, I probably butchered some of that. Let me turn it over to you, and let me suggest, since I do see Ms. Davis on the line, that even though we will have public comment for anything later, why don't you tee up for us what we need to know? Let's see if there's a motion that needs to be made, but we will certainly take comment from anyone in the audience who seems to be mostly our staff right now, and Ms. Davis, if she'd like to make it before we take a final vote on anything.
Okay. As you mentioned, we have been working on this regulation package for quite some time now, and after numerous meetings and a draft that was prepared after the comments that were made at those meetings, I sent an exposure draft to interested stakeholders. There was about 25 interested stakeholders that I sent it to, whether they were attorneys or representative of certain groups like EMA, et cetera. So after the exposure draft was sent, the last two commission meetings, we did spend a significant amount of time discussing those comments and what the commission would like to see out of those comments. So the commission provided direction to how to resolve those comments, and that regulations were revised based upon your direction. So the package that you have in front of you for review and approval today consists of, number one is the regulatory analysis form. This is a mandatory document required by Section 5 of the Regulatory Review Act. It details legal authority, the fiscal impact, necessity of the regulation, et cetera. The second document that you have is the preamble, which is the document that precedes the regulatory text whenever a proposed or final rulemaking is published. And similarly provides background, purpose, justification, cost, technical feasibility, et cetera, for the proposed rulemaking. And lastly, number 3 is the Annex A, which is the actual text of the regulations in their current form, along with the proposed revisions. And where it gets a little difficult to read sometimes is the text that is proposed to be deleted is in brackets, and while the text that is to be added is underlined. So if approved, the next step in this process would be to receive a fiscal note from the budget office detailing any fiscal impact the proposed regulation would have on the Commonwealth. I don't believe that this will have much of any fiscal impact, so I assume that we will receive a fiscal note similar to the one that we received with the technical package that we did. Once that is received, and that, if I remember correctly, only took maybe a week or two last time, it probably will be quicker this time now that they know who we are and what we're trying to do. Once we receive that, the formal regulatory process begins with me serving the standing committees. We have the House Judiciary Committee, and we have the Senate State Government Committee. The majority and minority chairs from both of those committees have to be served, as well as the Office of Attorney General, and then the Independent Regulatory Review Commission. The serving of those documents, honestly, is probably the most difficult process in this, is getting everyone has to have received them on the exact same day. And if I'm not able to serve one person and get proof of service for that same day, then the process has to start over the following day. So I'm hopeful that I'm going to pull a few strings and hope we'll be able to get them. And once they're served, they will be published in the Legislative Reference Bureau, and that opens up the 30-day comment period for anyone to make comments on the regulations. And those comments then have to be forwarded to not only the standing committees, but also to the Attorney General's office as well. So we received, I would say, a significant number of comments when we sent out the exposure draft, particularly from the Office of General Counsel, which I found particularly helpful due to their experience dealing with regs all the time. I'm hoping that having done that will cut down on the number of comments that we received to this package. I provided the entire package that you have in front of you, again, to the same group of stakeholders that are all listed in the regulatory analysis form, and I received only one substantive comment from an individual who actually received the package in error. But actually it was an individual who served on a similar board in the Commonwealth and actually took the time to read these regulations and what we were trying to do. And the only comment that this individual had was he wanted to ensure that removing the notarization requirement for a complaint would not cause an increase in any frivolous complaints. So all of that is a very long way of saying that I'm looking for a motion to approve the regulatory package in front of you, which will allow me to begin the formal regulatory process for the proposed regulations.
Rather than start with the motion, first I want to recognize two other people. Martin Harder, who I know behind the scenes played an incredible role, and also Commissioner Caruso, who on the very early stages went through a painstaking review of every single section of our regs that led to the ideas that led ultimately to the draft in front of us. The comment that you mentioned, I think it should be clear that while we eliminated notary requirement, complaints still have to be signed under penalty of perjury. That is the modern way of doing declarations that happen in federal court every day. So I don't think we're going to encourage any frivolous complaints, and we do have a wrongful use of proceedings that is still part of these regulations. Why not, before we make a motion, let's see if there's any comments that may impact any motion that we would make. Ms. Davis, just because I see you on the screen and we welcome you just listening in, but, and, you know, certainly no requirement to say anything today, but if you have any comments for us about the regulations, we welcome to hear them from you. I know you have provided very valuable comments in the past to our staff, and we appreciate that interest.
Well, I just wanted to say that, you know, you and the people of our Commonwealth of Pennsylvania are very lucky to have the staff that are before you today. I've had the pleasure of chatting with them over the years, and you're in good, capable hands. I would also just say that I personally really like the new definition you have for pecuniary gain. And I wanted to reference, there's this really great advisory opinion, confidential 15-501, which talks about the avoidance of costs that you would otherwise be expected to pay. And it's so well written and really clear, and in that kind of approachable way that I think a lot of people can understand it. So I don't know, good work, guys. That's all.
Well, thank you.
And I'm always around if you ever want to think about any other things. So, but yeah, thank you guys.
We appreciate your comments, and that avoidance of loss came up in a litigated case, Shern, I believe, that I also believe has been affirmed by the Commonwealth Court.
Yes, it
So,
has.
that is helpful. Any other comments?
Chair Swartz, I do believe there's another attendee on this call.
Oh, we also have online my intern right now. I don't know if you'd like for her to introduce herself, but I thought it would be good for her to see, you know, just to watch.
Sure. We don't require anyone to introduce themselves. They have an absolute right to participate anonymously. But if the person would like to introduce, we'd be happy to meet them.
Sure. Hi. Don't know if you can hear me, but I have been working with Leanne for about a year. And it's been a great experience, been learning a lot, and I'm currently a senior at Pitt. So it's great to attend today. And thanks for letting me introduce myself.
Wonderful. Well, it's a pleasure to meet you. Thank you. Seeing, hearing no other comments on the proposed regulations, do we have a motion? And I guess the motion would be to authorize our chief counsel to proceed with the next step of the regulatory approval as she has outlined.
I'll move.
Do we have a second?
Second.
Okay. Any comments, any further discussion on this? Seeing none, all in favor say aye.
Aye.
Aye. Any opposed? Motion carries, and congratulations, Ms. Guilfoyle, for putting this together and getting to the next step.
Hopefully it will move smoothly from here.
We put it in your good hands to get it served, and if there are comments, we'll address them. This would be the point in time for public comment. As I mentioned earlier, this is a meeting explicitly advertised to take public comment. Would anyone like to offer any additional comments? Hearing and seeing none, we'll entertain a motion to adjourn.
So moved.
Seconded. I see a second, and all in favor, say aye. Aye. We are adjourned. Thank you, everybody.